Welcome to the Gun and Ammo Buzz podcast. I'm Eric Poole, editor of Guns and Ammo magazine, and we have Keith Wood, a contributor who I'm familiar with. He contributes every month to the back page of Guns and Ammo, often the first place readers stop to read spent cases first. And in addition to general happenings around your life, you also talk quite a bit about legal issues and the ramifications of laws that get passed throughout the country. And the news as of today is Monday, February 3rd, as we're reporting on this, what happened on January 30th. And on January 30th, 2025, there was a ruling that came from the Fifth Circuit, and the appeals court said 18-year-olds can buy handguns, which is now going to set up the opportunity perhaps for a battle at the Supreme Court over this issue. Can you tell us a little bit about it?
Yeah, thanks for having me. That certainly could happen. The case is Reese v. ATF, came out of the Fifth Circuit Court of Appeals in Louisiana. The Fifth Circuit covers the states of Louisiana, Texas, and Mississippi. And just to set up a little bit of a understanding, there's the district court level. If you file a federal lawsuit, it's filed at the district level. That's the trial court. In the middle, you have the circuit appellate courts, and there are carved up all around the country. And then, of course, you have the U.S. Supreme Court above that. So this comes from that mid-tier, that Fifth Circuit appellate court, and they released this opinion.
Okay, so one question that a lot of people who may be distant from the issue here is, at what age can adults in the United States currently purchase handguns, and where did this age of 18 come from?
Yeah, so the age of 18, currently it's 21 and older to purchase a handgun in this country. And the 18 came from the Gun Control Act of 1968. And then there was rulemaking that followed that further clarified that. So basically, if you're 18, 19, 20, you can purchase a long gun. If you're 21 or older, you can purchase a handgun. There's no prohibition on folks younger than 21 possessing a handgun. And in some states, even getting a permit to carry one concealed. But it's the purchase requirement that was set up by the Gun Control Act of 68 and then the subsequent rulemaking.
What does the Founding Fathers, our Constitution, Bill of Rights, say about handguns, if you will, and how this appellate court ruling comes into effect?
Yeah, so that becomes important, and traditionally that wasn't considered by courts. But the Bruin case, which is New York State Rifle and Pistol Association v. Bruin, which was a challenge to the New York Sullivan Law, the New York may issue concealed carry law, basically saying it violated the Second Amendment. The U.S. Supreme Court released their opinion saying that, yeah, the Sullivan Law did violate the Second Amendment rights of these individuals in New York. And you may recall at the time on my back page, I said, look, this is a big deal for concealed carry. This is a big deal for New Yorkers, but it's a bigger deal for the kind of review standards set out by this case. Because for years and years, there was very little to no activity on the Second Amendment at the appellate level, and certainly at the U.S. Supreme Court level. That changed with the Heller case. Then there was the McDonald case, and then Bruin, took things a step further. And what Bruin established was this historical tradition of firearm regulation standard. That in order for gun control law to be constitutional, it has to be some historical tradition of that or something similar. So when this court looked at, bottom line, little procedural history here, this two individuals attempted to purchase handguns within the Fifth Circuit. They were denied the ability to do so. They filed a lawsuit in district court. The government, specifically the ATF, responded to the lawsuit, filed a motion to dismiss, and also said that the individual lacked standing. The court said, yeah, they do have standing. It was two individuals plus Firearm Policy Coalition, Second Amendment Foundation, I believe one in-state advocacy group. They said, yeah, they have standing, but they dismissed the case based on a rule. Those folks appealed up to the Fifth Circuit, and then the Fifth Circuit released this ruling. So that's where we are kind of procedurally. And the Fifth Circuit said the arguments of the government that were that these folks were not people in the context of the Second Amendment. So that 18, 19, 20-year-olds were not people, which is kind of a strange argument, but sometimes in cases like this, you kind of throw out what you have. the court said they are people and gave several reasons, both in historical context, in the plain reading of the statute, and in previous case law of why 18, 19, 20-year-olds are people relative to the Second Amendment, even going back to history of militia laws and things like that from this historical time. And then basically ruled that also that this restriction was inconsistent with the historical prediction. The way they put it, that the government provided scant evidence that there was a historical tradition of these types of regulations. So around the time of our country's founding into the 19th century, there was no history of restricting the rights of 18, 19, 20-year-olds from, purchasing firearms of any type.
So, as a consequence of this appellate court ruling, until it gets picked up by another court or even potentially the Supreme Court, does this change the law at a national level? Are current restrictions that prevent anyone from under 21 years of age purchasing a handgun, do those stay in place, or are those now dismissed as well?
Well, that's a good question. So procedurally, the court remanded the case back to the district court level because it was dismissed. It was never actually heard. It was never reviewed on the merits, on the facts of the case. So that'll happen now. Ordinarily, you would have the government, the ATF, DOJ, the administration, appealing this ruling up to the Supreme Court or up to a what they call an en banc panel of judges at the Fifth Circuit to re-review it. I don't see that happening necessarily under the Trump administration. This is a pro-gun administration who ran on gun rights. For him to appeal a pro-gun ruling wouldn't necessarily be something you would expect unless they did it because they wanted to get it to the U.S. Supreme Court. Because right now what we have is a conflict between circuits. The Fifth Circuit is Texas, Louisiana, Mississippi. So presumably this ruling applies there, and it's binding, what they call binding authority there, and it's persuasive authority in, let's say, California, but is not necessarily binding. And I spoke to a former senior DOJ official from the previous Trump administration. We kind of walked through what might happen today, and what you could happen. And first of all, BATF has not released any directives to dealers or anything like that. I don't think you're going to see any, immediate effect of this in terms of 18, 19, 20-year-olds being able to purchase handguns immediately, right? I think there's going to be a little bit of a delay as things pan out. But what you could see the administration saying, "Hey, this is a federal court's position. This is the law of the land now in Texas, Louisiana, and Mississippi, and we can't have differing laws. They need to be consistent. So we're going to apply this Fifth Circuit ruling across the country." I think that would be within the administration's rights to do that. I think you would see a challenge from a state attorney general in a Democrat state, state like California, Massachusetts, somewhere like that, would probably sue to challenge that. And then there's a scenario where the administration itself asks the Supreme Court to review it because they might think they have a good set of facts here, the law's on their side, and they feel confident that the Supreme Court would give them a favorable ruling that would then apply nationwide. But there's a danger to that too.
So when is the earliest possible resolution we can get for this? I mean, we see that the Supreme Court usually takes time to announce the cases that they're going to hear, and then they study those cases, and then often the ruling is postponed until no earlier than, say, the June, July, August timeframe. Are we looking at 2026 at the earliest before we could get some answers? How do you see it playing out?
Realistically, if it went the Supreme Court route, you're looking at 2 years minimum, and it could take far longer. So there's that. If the administration decided that it wanted to, use this to sort of force a change in policy, I think that could happen immediately, relatively immediately, as quickly as the government can move on something like this. We'll have to wait and see if that happens, but that would be certainly the quickest resolution to this. You could also see the court or even the Supreme Court issue a stay on the ruling until this, for example, the facts make it through the district court level. There are a lot of things that can happen, but for folks that want to run out and take this to the U.S. Supreme Court, I want to remind them that things don't always go your way. The Fifth Circuit ruled. Right. There was a case called the Rahimi case where an individual challenged the domestic violence injunction rule as violating the Second Amendment, and the Fifth Circuit agreed with him. Similarly to this case, sent it up to the U.S. Supreme Court, and the Supreme Court said 8-1 that no, that those rights can be restricted, that's not a violation of the Second Amendment. So now you've established a precedent that you don't like. So sometimes you have to be very careful about which cases you take to the Supreme Court, because then you're stuck with their ruling.
So if one day this ruling allows 18-year-olds to 20-year-olds to purchase handguns, do you then see as a ripple effect any consequence to concealed carry laws in state to state, or any potential national reciprocity law? Could that be affected? And what are the ripple effects of this case if it goes one way or the other?
Yeah, so let's just say that, this case gets elevated to the Supreme Court, they act very quickly, and they rule, similarly to the Fifth Circuit here, that 18, 19, 20-year-olds should be able to purchase handguns. I think it had huge ripple effects. I think it would affect concealed carry laws in the states. Some states already allow 18-year-olds to carry. I think you would see more conservative states move to quickly pass laws to that effect, right, consistent with this ruling. You would also, I think, in states that don't do it, see legal challenges to those age requirements. So I think that would have long-lasting and huge rippling effects. And is, we talked about in a recent back page, the national reciprocity as a bill moving before Congress that the president has said he supports. You could see that incorporated into that bill preemptively, knowing that this issue may come along. That could be placed in that bill. So I think it certainly would have far-reaching and important consequences on the concealed carry side across the country, both in the courts, in legislatures, and in Congress.
What prevents those under 18 years old from being grouped into this 18 to 20-year-old demographic on this topic?
Well, there's a lot of, it's interesting, a lot of this opinion, when you read it, gets into the nuances of age. And there is one reference to minors even younger than 18. They don't take the step of applying that to this case, of saying that folks younger than that should be able to purchase handguns, but it is mentioned. I don't necessarily see things going there, but it's an interesting argument, right? But this, the 18 is consistent with voting. It's consistent with military service, although you can serve younger, and plenty of folks have. The ability to sign contracts. 21. Alcohol is that kind of changed things there, right? But before that, states like Louisiana, for example, 18 was the age to drink. So,
right. But topics such as alcohol are not necessarily protected by the Bill of Rights, as the Second Amendment lays out for firearms and our ownership and the right to bear. So this is
there's no right to drink.
Different
I don't think. Yeah. It's 18 seems to be, in the reasoning of the court, where the line should be here. And of course, Congress felt otherwise when they established, the Gun Control Act, and we'll see where this lands. I mean, folks, you could debate the appropriate age till you're blue in the face, but we'll see where the law actually lands here. This court at least believe that 18 is the correct place.
This is an interesting period in terms of what we're seeing coming from the Supreme Court, from laws around the country. It'll be interesting to see where this goes and what other laws are affected by the consequences of these rulings coming out of the Fifth Circuit. Keith, thank you again for joining us on the Buzz podcast. We appreciate your time here. And what an interesting topic that's worth following. Be sure to keep up with it by visiting gunsandammo.com and keeping up with the Guns and Ammo Buzz podcast.